There.
Court does call the case People versus Brandon Kelly.
Al Chabalowski for the people.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Kelly, who's here to my right. Judge, state your name, Mr. Kelly.
Brandon Kelly.
I think these are the rights that I went over with you, okay? I will start this out. Sign. Put your address. And then. Here, I'm just having Mr. Kelly sign the advice of rights that I went over with him orally in the lockup. This is just saying that the felony is going to be dismissed and you're pleading to it. Okay. Sign there and date there. Your Honor, we have executed an advice of rights in a plea form and a sentencing judge waiver.
The plea form indicates that the defendant will be pleading. Hey, you didn't check the box. It's a no contest plea.
It'll be a NOLO plea, yes, Judge. The reason being civil liability.
They will be pleading no contest to the charge of aggravated assault. The 1 year offense, upon a successful plea to that charge, count one would be dismissed. That's the court's full understanding of the.
That is correct, Judge. There is no sentencing agreement in this matter.
Correct.
All right. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Brandon Kelly.
All right, sir, it is this court's understanding that you're going to plead no contest to the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
Two things about a no contest plea I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes.
All right. Understanding all of that, you still wish to plead no contest?
Yes.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
Not this time.
All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
I have been provided and have reviewed Ann Arbor Police Department report for their case number 2531672. Any objection to the court having reviewed that report?
No.
No from the defense, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to any sentence evaluation or recommendation. The court would not be bound by that, I should say, and you would not be permitted to withdraw your plea. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No.
No, Judge.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes.
Defense is satisfied, Judge.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
November 4th at 9 a.m.
November 4th, 2025, 9 a.m. That is before Judge Valvo.
If I could be heard on bond, Judge.
Sure.
Your Honor, Mr. Kelly is here on he's a 5,010% bond. He has resolved the felony matter. He has taken responsibility in this matter. His mother has been in court with him every single time, and she's in the front row here. She says that he is welcome to stay with her while he's out for sentencing, and we'd ask the court to grant him a personal recognizance bond, and with any conditions. I think he'd welcome any conditions that would ensure the safety of the public, up to, including potential tether and no going to target. This is an event that happened. Well, you read the police report, you know what happened.
Yeah. Well, I'm concerned about why it entirely happened from his perspective. I guess maybe I'll ask it a more direct way. Are there CMH issues?
Yes, Your Honor. He has there are CMH issues. He has an alternative treatment order. He has received his shot. I believe he's just received it not too long ago. Is that correct?
Yes.
When was the last time you had him?
I can't remember.
But I don't think he'll be due for another shot before he's sentenced. Is my understanding. Don't quote me, but last time he and I spoke, he had just gotten it, and this matter was set for an exam.
Is this right? Is this his only case?
I don't believe there's anything else holding him, Judge. No.
Okay.
That's what it looks like.
And,
I think it's 5,000.
right. And the treatment plan is through probate court, I presume.
Yes, I believe so. If I could just have 1 second, Judge, I have my notes in the.
Well, I guess the other thing I want to know is, was he on the treatment plan prior to this event?
If not prior, Judge, I believe that the two may have coincided.
Well, I get, okay, so here's what I'm trying to figure out. If he's on the plan prior to this event, and then after this event, he then gets onto the plan, that's one thing in my mind. If, however, he's on the plan prior to, maybe not cooperative with that, and then this happens, that's a different issue for me.
Your Honor, he reports that he's just been receiving the shot for the last month.
Okay.
It would have been after the plan. This precedes the shot here.
What I will do is, I'm not going to give a PR, but what I would indicate is that I will reduce his bond to a 1,010% bond. I really would prefer that Judge Bravo, since she has it, take a look at it, given her history with the mental health court. Take a look at it. I'll reduce it to the 1,010% bond. I will also indicate prior to his be placed on the GPS home confinement tether.
And I will get that address to the court, Judge.
All right, very good.
Thank you.
Thank you.
Mr. Goldstein is going to give us a call as soon as his client.
It's a guilty.
Yes, sir.
Do a misdemeanor, I'm presuming. Court does call the case of the people versus, is it Antoine Pitts?
Counsel for Assistant Prosecuting Attorney on behalf of the people.
David I. Goldstein appearing on behalf of the defendant. Your Honor, I have the plea agreement and the vice rights as soon as he signs them. All right. Okay. Antoine, you just sign right there. And 14. Okay. And this is the advice of rights form. You've been over this before. You need to sign it right there.
Plea form that has been given to the court is that the defendant would be pleading to an added count 3 of use of a controlled substance, a 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. There is also an agreement that the prosecutor is going to recommend release on a PR, and he signed the sentencing judge waiver. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That is correct, Your Honor. Thank you.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth and the whole truth and nothing but the truth, so help you God.
Yes,
State your name.
Antoine Pitts.
All right, sir, it is this court's understanding that you are going to be pleading guilty to a charge of use of a controlled substance,
Yes,
correct? That's a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. You understand that, sir?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Probation.
Okay, were you on probation at the time this happened?
Yes.
All right. I need you to understand that this could be considered a violation of that probation.
Yes.
You understand that if it is considered that, that court could sentence you to the maximum allowable under that other charge. You
Yes.
understand that? And understanding that, you still wish to plead guilty to this one?
Yes, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will?
Yes.
All right. And because you believe that you are guilty?
Yes.
December 3rd, 2024, at the location of Bryan Circle at or near Thetford. Did you have cocaine in your possession?
Yes.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
All right. The court has to also advise you, sir, that if you commit misconduct as defined by the Michigan court rules between the time of my acceptance of your plea and the time of sentencing, the court would not be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None that I'm aware of, Your Honor.
No, Your Honor.
All right. And sir, and counsel, have I complied with the court rule?
People are satisfied, Your Honor.
I'm satisfied, Your Honor.
The court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
November 18th at 10 a.m.
November 18th, 2025, 10 a.m. before Judge Barr. There is an agreement for the release at this time.
Your Honor, the answer is yes, but I'm going to ask the court to do something which is a little bit abnormal. We're asking that the bond previously set, which had been posted, be reinstated, but we want it effective as of next Monday. The reason for that, he is on probation to Judge Hammoud. We have a hearing in front of Judge Hammoud, and as of right now, he's not going to be released. So we'd like the clock to keep running at least until
Gotcha.
Monday.
So when's your hearing before Judge Hammoud? On
Monday, the 20th.
the 20th?
Yes, Your Honor.
And all right. So what I will do with reference to his bond, at this point, I will continue his bond, but then defendant to be defendant's previous bond effective October 20th, 2025. And I'm just going to put in brackets on here that defendant has posted prior bond. If that's what you want.
Thank you, Your Honor. That's for me. I'm not here.
Is it you?
Absolutely. Sorry.
Was it?
Yeah, it was.
The heck?
I know, right?
The heck?
Send me home.
Get out. No, give your phone to Alan. Thank you, sir.
Granted in part, denied in part.
Yes.
Okay.
Yeah, granted in part, denied in part. I wrote it,
Yeah, I saw
so you just put it.
Cool. That's a plea.
Court does call the case. People versus Makisha Melkor.
I'm Deputy Public Defender Pickford, and on behalf of Ms. Melkor, please state your name for the record.
Good morning, Your Honor. My name is Makisha Melcher, and I apologize for being late. I'm sorry. I was at work and rushing this morning, forgot my court date. I didn't look at my recovery calendar.
You know what? I'm going to like you.
Thank you.
Yeah, no, the only reason is because you confessed to something I didn't know.
Yeah.
We're gonna get along just fine. All right. Apologies accepted. Man.
Thank
That's
you.
fine.
So,
All right.
today's the date and time set for PE. We have a plea agreement worked out. My client has signed, the waiver of, examination. We're ready to.
All right. And it's mine anyway. All right. And the plea agreement I have before me indicates that she's going to plead guilty to an added count to a retail fraud in the second degree, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Yes. May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth so help you God.
Yes,
State your name.
Keisha Melcher.
Okay. Well, it is this court's understanding that you're going to plead guilty to the charge of retail fraud in the second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, ma'am?
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes, I am.
All right. Were you on probation at the time of this offense?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
March 30th, 2024, at the location of 3300 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. What did you do at the Home Depot that makes you think that you're guilty?
I entered Home Depot with someone and attempted to take something.
What were you trying to take?
Flooring.
Flooring.
Someone flooring.
All right. And so you were trying to walk out of the store without paying for it?
Yes, I accomplished someone. Yes.
Okay. So just so that we're clear, when you went in, this other person that you were with, the two of you were really acting in concert to get out of the store without paying for the flooring.
Yes, yeah.
Was that correct?
Yes, sure.
All right. And the value of the flooring, was that in excess of $200? Well, we'll do it this way. You have subsequent convictions for retail fraud.
Yes.
In the 24th District Court in 2017 and in the 34th District Court in 2024. Is that correct?
Yes.
All right. Store was open to the public at the time?
Yes, Your Honor.
You didn't have anybody's permission to take that property, did you?
No.
And this property you took was property that was offered for sale by Home Depot?
Yes, Your Honor.
Ma'am, if I accept your plea and you commit misconduct as defined by the Michigan court rules between the time of my acceptance of your plea and the time of sentencing, you understand that you would not be entitled, or the court would not be bound by any sentence evaluation or recommendation in the case.
Yes, Your Honor.
All right. And you also would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes. The defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be November 12th, 2025, 9 a.m. That's before me. We'll continue.
Thank you, Your Honor.
So next time you're going to be on time, right?
Yes.
Okay, me too. We'll be fine. All right. Thank you. Court does call the case. People versus DeMarco Henderson.
And Alex Warren Green on behalf of Mr. Henderson.
Your Honor, it's the date and time for preliminary examination.
It is.
I've been in contact with Mr. Henderson. He is currently before the Honorable Judge Gillis of the Third Circuit Court. I was able to obtain the Register of Actions from that court and confirm with the people that he is appearing for a final conference there. I'd respectfully ask the court to consider adjourning this matter such that Mr. Henderson can appear at a future date.
I leave it to your discretion.
So why did you choose there and not here? Is
Your
that a
Honor,
criminal case he's before on? Is before Judge Gillis on, or?
it is. It is a resisting and obstructing charge. Yes, it's a resisting and obstructing charge as bound over and set for trial there. I'm not sure, Your Honor. I think he may have flipped a coin.
Did I win or lose?
He's in Judge Gillis' court, so.
So I won.
Yes.
Preliminaries. Are the witnesses here on this case?
We didn't have anything.
You let them go.
Yes.
So, okay. You guys anticipated what I might do. Preliminary examination in this matter will be adjourned. It's Judge Washington's next day. October what? She's here? October 28th, 2025, 9 a.m. before Judge Washington.
Thank you, Your Honor.
Thank me and Chuck, because if he had asked for a warrant, I would have said yes.
Thank you, Mr. Kozlowski.
Let's call the case of the people versus Malik Lester.
Questions? Any for Hannah?
And Alex Warren Green on behalf of Mr. Lester. Mr. Lester, could you state your name for the court?
Malik Lester. All right, thank you.
Your Honor, in speaking with Ms. Tana, she indicated the people were unable to proceed on count 1 and indicated that counts 2 and 3, the people would be requesting a remand. With that, I would move to dismiss count 1, and I have no objection to the remand.
You're gonna check. No, it's okay. She just left you here, told you, just cover this, I'm gone. And she walked out, right? That's so Tana. Go ahead, everybody can talk about her. Don't just look at me like I'm talking crazy.
She doesn't hide the ball.
Huh?
She doesn't hide the ball.
No, she doesn't.
Told me straight up.
What you done? Never mind. I'm going to be patient. Nah, it's not. No. Oh, so why is she here? Why is she here? I thought she left. That's why I was feeling uneasy. Bye. Why were you in here? So who did bad? You got notes? Let me read them. Take care. So everybody just left.
Seems like it.
Miss Yagi, it's good seeing you. We miss you on Thursdays.
It's good to see you, Your Honor. I was going to say, I know that it wasn't me because my case hasn't been called yet, so.
What was that, a dig? Was that a dig? It's like my case hasn't been called. What are you waiting on, Judge? You did no. I hear you. No, it's okay. It's okay. I'm not offended. Jeez, oh Pete.
It's good to see you.
Here, Alex Chavalowski, I've got people are unable to proceed as to count one on Mr. Lester's case. We would ask that counts 2 and 3 be sent back to this.
Your Honor, we would move to dismiss count 1.
Count 1 is dismissed. I'll continue as not guilty pleas as to counts 2 and 3. I'll set a pretrial on this matter. I could set it for tomorrow and you could be in with a mix of 200. You don't want to do that. No, I'm not going to. There's like 200 cases set. We'd lose him. Let's give him another day.
November 3rd.
Set pretrial in the matter November 3rd, 2025, 9 a.m. That is before me. Okay.
I'll be in touch with
Bond will continue. Thanks.
Thank you, Your Honor.
I don't know. This one,
That one's Miss Tana.
yeah.
And
These,
then
these two and Mr. Chavalowski.
what did Tana do? She just left. Did she leave you with another case?
She's with Judge Alvo at the moment.
These people choosing other judges over me. This is like the second, like a defendant did it. Now Tana.
I don't know if that's
What?
I'm not sure.
Don't say anything because then I got to tell Judge Alvo what you said. So just let it rest. So
So this is Mr. Chavalowski and Mr. Warren, who I believe they're holding.
you're holding on Burke?
Max Stewart and Mr. Warren Green, I think, is going to try to talk to Mr. Burke.
So, okay. So what did you just say?
So he said they're holding on that. I was given one witness,
Okay. Who's on the other side of that one?
Mr. Donovan.
You're on the other side of that one. And then you're going to go talk to your client.
If that's okay, Your Honor, if the court can accommodate that, I would like an opportunity to speak with other people related and offer in that case.
Why in the heck can't you just say yes? I'd like, why? That was the longest, like, yes, I need to talk to my client. Go talk to him.
Our new union contract.
Yeah, that's the union contract.
President Apple has negotiated a new contract in which we get paid by the word, Your Honor. And we've managed to ship our previous terrible president to the other.
You know what? I'm just going to cut you off then, Owen. You're getting paid nothing today. All right. So I've got that one. That one's ready between these two.
Correct.
What was?
And then Miss Yagi is with Miss Tana.
Oh, so you're on the other side of long lost Tana.
Yes, Your Honor.
Okay. So you've got your witnesses. There's one witness on the Mark Stewart matter. Is that right?
Yes.
Okay. Let me take a brief break. I'll come back out because we got to have him from the back, and then that'll give what's his name time, and maybe I can clear those two. And then Tana will grace us with her presence. All right. Thank you.
All right.
And that brings us to the close of today's PCC docket session. Judge Simpson and the court efficiently worked through a challenging docket, reaching final dispositions in several key cases and setting the next steps for others. The plea decisions, we saw 3 defendants enter pleas today, resolving their cases at the district court level. First, in the matter of Brandon Kelly, who faced an aggravated assault charge, Kelly entered a no contest plea to the reduced misdemeanor. This specific plea was chosen by his defense counsel to protect him against potential civil liability in the future, a common strategy when a separate lawsuit is possible. The core of his case, however, revolved around his bond. Acknowledging confirmed mental health issues, the judge denied a direct release on a personal recognizance bond. Instead, the court reduced his financial bond significantly, but added a crucial public safety condition, GPS home confinement, upon his release. This ruling underscored the court's commitment to balancing judicial compassion with the need for community safety. Kelly's sentencing is now set for November 4th before Judge Valvo. Next, we heard the case of Antoine Pitts, who pleaded guilty to the use of a controlled substance. A key point here was his status as an individual already on probation. The court explicitly warned him that this new conviction could trigger a probation violation, potentially leading to a maximum sentence on his prior offense. In a highly unusual but cooperative move, his defense attorney requested a delayed release on the existing bond. This was granted, making his bond effective on October 20th, a delay requested so he could first address his existing violation hearing before his probation judge. Pitts will return for sentencing on November 18th. Finally, we covered the case of Marisha Melcher, who pleaded guilty to retail fraud in the second degree, a charge based on her admission that she and another person attempted to steal flooring from a local Home Depot. Her plea was accepted, and she will be sentenced before Judge Simpson on November 12th. The adjournments and next steps, the court also had to manage its calendar and coordinate with other circuits. In the case of DeMarco Henderson, the defense asked for an adjournment on his preliminary examination because Henderson was busy appearing before another judge on a separate felony resisting and obstructing charge. The court granted the delay, pushing his preliminary exam back to October 28th. Similarly, in the matter of Malik Lester, the prosecution admitted they could not proceed on the most serious count. As a result, the court dismissed count 1 of the charges and remanded the remaining counts back to the lower court. A pretrial hearing for Lester has been set for November 3rd. Today's session was a perfect example of the busy docket of a modern district court, highlighting the complex judicial process involved in moving cases from initial charge to final disposition. Whether it involved managing mental health conditions, coordinating with other courts, or simply accepting a guilty plea, the day's work ensured every case took its next step toward final justice.